Francisco, I think that they should just name themselves and just to know who they are.
Perfect.
Good afternoon, Honorable Tribunal. My name is Nkrumah, and my co-counsel's name is Vincent Fach. We represent the appellant, Mr. Arthur.
Pleasure.
Members of the panel, my name is Firas Aidi, and I'll be pleading the procedure for on behalf of Respondent, and my co-counsel Shahrazade Sabil will do the same for the merits. And for this tribunal, both teams put their names in the chat in the Zoom meeting, so you can also find them there. Thank you, members of the panel.
Thank you. Much appreciated. So I understand we're still waiting for the recording. Is that correct?
That's all good now. So on my side, everything is perfect. I will leave now the floor to the panel and to the president to introduce yourself and let this hearing start. Thank you very much.
I'm sorry, can the Stockholm University also put the name in the chat, please?
Honorable Tribunal, we've also put our names in the chat.
Okay, not yet here, but
It might happen that if the panel was in the breakout room while the chat was written, they cannot see it. So if you can please repeat your message, thank you.
Yes, the same happens to me. Thank you, madam. I think at some point we'll also need to ask the same thing from Université Paris-Saclay.
Yes, we will put the names again, members of the panel. And simply before we begin, we'd like to apologize for the inconvenience. If we disappear from the screen because of the background, we apologize. We promise you we'll be here the entire time. Just the background keeps bugging when we move.
It is not a problem. Thank you. So when everybody is ready, we can start the clock for appellants. We're all ready?
Good afternoon, Honorable Tribunal. In the matter of Atom versus FIFA, my co-counsel, Mr. Vincent Fach, and I, Ms. Nkrumah, represent the appellant, Mr. Atom. We are here today because our client has been accused of a very serious crime, which not only is to be judged by a biased arbitral tribunal, but is also relying on inadmissible evidence. On this backdrop, Counsel for Appellants submits that this CAS tribunal has jurisdiction to hear the present appeal, and this jurisdiction derives directly from Article 58.1 of the FIFA statutes. We would like to note that this appeal was lodged within the 21 days limit requested, and highlight that opposing counsel is also not challenging the jurisdiction as shown in the skeleton. Counsel for Appellant will focus on two main procedural issues at hand. Firstly, on the challenges to Mr. Vax and Mrs. Omaima, and secondly, on the admissibility of evidence. Moving on to the first procedural issue, which is the challenges to the arbitrators, Counsel for Appellants submits that these challenges must be upheld. As per Article 33 of the CAS Code and Article 180C of the Swiss Villa, an arbitrator needs to be independent and impartial throughout the whole arbitral proceedings. However, both arbitrators fail to meet the standard of impartiality required. Counsel for Appellant will now focus on the first challenge, which is to Mr. Vax. We submit that this challenge is admissible and substantiated. Focus on the admissibility, Counsel for Appellant would like to highlight that the duty of curiosity, and as well as Article 34 of our challenge, states that we need to present our challenge 7 days within time limit of knowing of this ground for challenge. And in this circumstance, the challenge arises out of a LinkedIn comment posted by Mr. Vax. Counsel for Appellants submit that the duty of curiosity was fulfilled when the LinkedIn comment was actually read by a legal member of Appellant, which was only 3 days before the hearing, Honorable Tribunal. And on this note, we kindly ask the Tribunal to consider the case of the Swiss Federal Tribunal of December 2020 with case number 4A_318/2020. In this case, the Swiss Supreme Federal Tribunal was revising a cast award in regards to the Sunyan case. And here it was stated that a party is now requested to have a systematic and thorough search of all the readily available sources, specifically due to the ever-evolving number also of social networks. If we apply the same principle, LinkedIn is a social network, and thus Appellant was reasonably not expected to look at all these comments. In the Sunyan case, the arbitrators' tweets were public, but the tribunal held that even if the tweets were public, this was irrelevant. Now, focus on the substance, we submit that the circumstance and the comment meets the threshold required under Article 34, as well as what has been established in the Sunyan case. In fact, the contested circumstances that give rise to doubt as to the impartiality of an arbitrator looks at the appearance of bias. And this is based on a third-party objective bystander, Honorable Tribunal. On this note, we ask the Tribunal to look at Exhibit 7, which can be found at page 27. Is the Honorable Tribunal with me? Here, we can see that Mr. Vax was not only advocating in favor of vaccinations. Honorable Tribunal, we would like to point out that Mr. Atom is known to be against vaccinations, and this is publicly known. And Mr. Vax is advocating against people that oppose vaccines by referring them as uneducated people who only think about themselves and who are egoistic. Mr. Vax is to deal with a serious allegation of bribery, which often has connotations of egoism and self-seeking for these people that have been accused of bribery, Honorable Tribunal. Furthermore, he's asking for an active ostracization of unvaccinated people from society by stating that they pose a danger to the life of others and that they are a risk to the public health. So he must be recused from these proceedings. Now, looking at the challenge to Mrs. Omaima, we submit that this challenge is also admissible and substantiated, and she must either provide us with information or recuse herself from these proceedings. Under Article 179 of the Swiss Pillar, an arbitrator is under an obligation to actually provide circumstances that might give rise to doubt as to their impartiality. We would like to note that Mrs. Omaima provided us at the last minute that she had acted as an arbitrator in proceedings involving FIFA. However, Honorable Tribunal, we did not know about the nature of these arbitrations. It's just noted that it was previous proceedings. It could have been commercial arbitration. There's no mention of sport arbitration, Honorable Tribunal. And for to provide us for clarification of the appointment procedure and the outcome of this case, she has still not provided all of this information, and thus there's legitimate doubt as to her impartiality, Honorable Tribunal, and she must be recused as well. Now, focus on the second and last procedural issue at hand, which is the admissibility of the evidence. Counsel for Appellant submits that this evidence is inadmissible. Now, looking firstly at the anonymous witness statement, we submit that admitting anonymous witness statement infringes upon appellant's right to be heard and right to a fair trial, which can be found in Article 182 of the Swiss Pillar, as well as Article 29 of the Swiss Constitution. And also, we ask the tribunal to consider Article 6.1 of the ECHR. We kindly ask this tribunal to consider the cases of Pobeda versus UEFA with case reference 1920 from 2009, as well as the cases of USI versus Contador with case number 2384 and 2386, and as well as the case of Karim Karamuddin versus FIFA, which was from 2018 with case number 6388. And here it was stated that we can admit anonymous witness statement as long as it does not infringe upon the rights to be heard, and that it is further support to other evidence, and that the other means of cross-examination are provided. And therefore, the strict condition must be met. These strict conditions often are like, there must be a threat of safety, as well as providing other cross-examination tools, such as audiovisual protection, or by distorting the voice of the anonymous witness statement. However, if we look at our present case, Honorable Tribunal, this evidence is one of the key evidence relied upon by the opposing counsel, and furthermore, no cross-examination was provided to Mr. Atom. The witness statement is alleging threat to safety, but this cannot actually be provided. Therefore, we ask this tribunal to alternatively provide us with further cross-examination tools by using its de novo powers. Moving on to the second and last evidence provided, which is the telegram messages. These telegram messages also infringes upon Swiss public procedural public policy, Honorable Tribunal. We ask the tribunal to actually consider the case of Football Club Metalis versus UEFA, which has case number 3297. And here it was stated that we can actually admit unlawfully obtained evidence as long as it does not infringe upon fundamental rights of procedure. The right of fair trial has been enriched in the Swiss constitution in the Swiss pillar, as we've already enunciated, Honorable Tribunal. Furthermore, we want to highlight that there is no information as to the identity of the hacker. We were not able to cross-examine them. Thus, how can we be provided with this? We also asked the tribunal to consider the case of Guillermo Lazo de la Rica with case number 3467, because the chain of custody has also not been preserved, Honorable Tribunal. If we compare to the Guillermo case, in that instance, the extracted information had actually been confirmed by the witness statement. In this instance, we do not know where this information comes from. Thus, to conclude, Counsel for Appellant submits that this CAS tribunal has jurisdiction to hear the present appeal, that the challenges to Mr. Vax and Mrs. Omayo must be upheld, and that the evidence is inadmissible. Thank you, and it has been an honor to plead in front of you.
Thank you, Madam Nkrumah, I think that's how you pronounce it, and if not, I apologize. You were just in time. Distinguished colleagues from the University of Paris, the floor is yours.
Thank you, Mr. President. Mr. President, members of the panel, as already introduced myself, my name is Firas Aidi, and I'll be pleading on behalf of Respondent FIFA in these proceedings. We'll be making three main submissions before this panel following the same structure used by counsel for the appellant. First, we will say that we do not discuss the jurisdiction of CAS. However, the appeal is inadmissible, and by duty to arbitrate in good faith, we accept that this appeal will be heard. Second, in regard to the challenges, we submit that both these challenges should not be upheld because they are groundless. The presiding arbitrator and Ms. Umayma are both impartial and independent. And finally, our third submission deals with the evidence. We submit that the two pieces of evidence, Exhibit 4 and Exhibit 5, are both admissible. Thus, to begin with our first submission, we do not discuss the jurisdiction of CAS here. We have already reached an agreement with counsel for the appellant. However, the admissibility of said appeal is of question. And based on Article 82, Paragraph 1, it should have been done earlier, since the decision of the Ethics Committee was notified on the 31st of May. and the duration of 21 days was not respected. However, as I have already mentioned, we agreed with counsel for the appellant to not discuss this point. Thus, in the duty to arbitrate in good faith, we will not make any further arguments. Moving on to our second submission, members of the panel, dealing with the challenges of first Mr. Vax and second Ms. Umayma. I'd like to react on the comment made by counsel for the appellant regarding the duty of curiosity. The appellant clearly stated that this duty has been fulfilled. However, we humbly disagree on that case. First of all, the comment by Mr. Vax was done on the 20th of November, 2021, and the panel was constituted on the 29th of November, 2021. And counsel for the appellant said, and I quote, "We cannot look at all the comments of Mr. Vax. Paragraph 12 of page 4 of the case pattern clearly states that this is the only comment made by Mr. Vax. Thus, we submit it would have been an easy task for them to look on his LinkedIn account, to look at search his full activity, and only one comment would have appeared, and that comment would have been the alleged one. Thus, if counsel for the appellant would have fulfilled their duty to would have fulfilled their duty of curiosity, they would have done the necessary research, and they would have made their challenge before this hearing here. And before we develop further, allow me to remind the panel that this is not the correct venue to form such a challenge. Indeed, Article R34 of the CAS procedural rules provides that a challenge will have to be done in written, submitted to the ICAS, and then the ICAS will decide on such a challenge. However, for the sake of the argument, we will still prove that both the challenges are here groundless. Regarding the lack of impartiality of Mr. Andrew Vax, we do not have enough elements that would give any rise to doubts over his lack of impartiality. He only stated an opinion, which should be expected from a president of an NGO that deals with the eradication of diseases. And the words that he used, members of the panel, when he said that this derives from people's constant exposure to fake news and proneness to conspiracy theories, numerous studies suggest the same information. We have studies by Oxford University, by MIT University, that all suggest that people who are hesitant towards vaccination are all people with lower levels of high education. Thus, this is simply an opinion. And these comments were not directed towards the appellant, were not directed towards a community or a nationality that will derive from the appellant. If I may give you an example, the Sun Yang case, in which an arbitrator had words that I do not even dare to quote before this panel. They were directed at the Chinese population in general, and the appellant in these proceedings was a Chinese swimmer. And even in that case, when he insulted them and said they belong in hell, ICAS did not give grounds to the dispute, and when the challenge was made before the Swiss Federal Tribunal, it was also denied. Thus, members of the panel, we conclude on the submission. We submit that the challenge should not be upheld, even if we switch this comment over vaccination with any other topic. It does not have a direct link with the allegations of corruption. Thus, we submit that Mr. Vax should be maintained and the challenge should not be upheld. Moving on to the second element dealing with challenges raised by counsel for the appellant, it's in regard to the challenge of Ms. Umayma. Here, members of the panel, first of all, Ms. Umayma did disclose the information as clearly stated by counsel for the appellant, and I refer to Exhibit 8. That would be the last page of the fact pattern. And I quote, if members of the panel are with me, please note a former member of FIFA's in-house counsel has recently joined my team as my firm as an associate. In regard to the fact that she was appointed multiple times, this does not give rise to legitimate doubts or justifiable doubts or any doubts for the matter. In CAS, this is a closed list system. If I may give you some statistics, and all these numbers are available on FIFA's website under the section awards. From October 2019 to February 2022, FIFA was party to 219 disputes. The number of arbitrators that are competent and specialized in football is only 112. Thus, it is mathematically impossible for FIFA to appoint a different arbitrator every time. Thus, Madam Umayma did not even have the obligation to disclose such an information. In regard to the date of the disclosure, as counsel for the appellant said, allow me to remind you that the former FIFA in-house counsel joined her firm on the 1st of March 2022, and she disclosed it the 2nd of March, the day after this FIFA in-house counsel joined her firm. Thus, there are no elements that would give rise to her to any legitimate doubts. And the fact that she did not disclose any verdicts of the awards is she was simply following the rules of CAS. Article R43 states that there is an obligation of confidentiality, members of the panel. She could not have given this information, even if she would have wanted to, without violating CAS rules. Thus, we conclude on this point by clearly stating that both the challenges should not be upheld. Moving on to the last element dealing with the evidence, we'll be making the same two arguments. First, in regard to the witness statement, and second, in regard to the screenshot. Members of the panel, allow me to clarify the situation here. The anonymous witness statement is not a witness that FIFA has heard or FIFA has presented. This is simply a document that FIFA acquired from another jurisdiction, which is the Hardlandian jurisdiction, in order to appear as a document, not as a witness or as a person to listen to. Thus, the case of Pubeda, other cases such as Quintador that counsel for the appellant could have given you, shall all here be distinguished. Here, this is not a question of admissibility of evidence. This is a question of evaluation of evidence. And the said evaluation is the discrete power of the CAS. And here, I refer to the relevant article of the FIFA Code of Ethics, which is Article 47. And I quote, "The Ethics Committee shall have absolute discretion regarding proof." This is not an issue of admissibility. The fact that the appellant was not able to cross-examine is simply here irrelevant. The only information that matters here is we have a document that clearly states that the appellant has breached Article 27 and accepted the advantages, and this will be developed by my co-counsel, Ms. Sabil. Finally, in the last 2 minutes that I have, I will move on to the last element here, which is the screenshot that has been presented by the Ethics Committee of the Telegram conversation. That will be Exhibit 5 of the case pattern, members of the panel. Counsel for the appellant quoted the Metalist case, and she clearly stated that in the Metalist case, evidence was not admitted if it violated the personal rights of the appellant. Even in the Metalist case, they admitted illegally obtained evidence. Thus, if the case on which the appellant solely bases its argument on has admitted illegally obtained evidence, then we submit that this panel should also accept. This has been a standard practice in CAS awards. In the Valverde case, the evidence that has been illegally acquired by the Italian courts were admitted before CAS. Thus, we submit that even illegally obtained evidence should be admissible in these proceedings. The only article that deals with illegally obtained evidence is human dignity, which is Article 46 of the FIFA Code of Ethics. Nothing here amounts to a violation or to psychological or violence on the appellant. And the final comment we'll be making under the use of Swiss law, even Article 28 of the Swiss Civil Code clearly states that a balance of interest shall be made between the personal interest of the appellant and the public interest. Here, we submit that the search for the truth, that the gravity of the allegations of corruption override the appellant's personal rights. Members of the panel, the final 20 seconds I have, I will summarize, 45 seconds, apparently. Thank you, Mr. Arbitrator. I will summarize our arguments and finally conclude. Even though the appeal is inadmissible, we submit because we reached an agreement with counsel for the appellant and following the duty to arbitrate in good faith, we will not discuss this element. In regard to the challenges, first, the challenge that will discuss the lack of impartiality of Mr. Rax is inadmissible and should not be upheld. Ms. Umayma does not lack independence and the challenge should not be upheld. And finally, the two pieces of evidence presented here are admissible because they take into account the gravity and of the sanction, the gravity of the allegations and the situation here. I conclude my submission and I thank you for your attention, members of the panel.
Thank you very much, Mr. Aidi. I understand that now we will proceed with Stockholm University with 1 minute. Is that correct? Okay, floor is yours, madam.
Honorable Tribunal, first of all, on the jurisdiction, we want to highlight that the FIFA Appeal Committee ruled that the adjudicatory chamber decision was a matter of Article 81. Thus, it did not deem it to be final and it sent it back to the appeal. This is why we are currently, we appealed to the FIFA appeal and it became final as requested by Article 81. I want to also highlight that we stated that the duty of curiosity arises when we know the circumstances. And this has been stated also in the Sinyan case, which clearly states that the party cannot be asked to look at all the regular available sources. Opposing counsel is relying on the mention of personal rights, but we are discussing Swiss procedural public policy, Honorable Tribunal. We mentioned Article 29 of the Swiss Constitution. And thus, in the Metalis case, opposing counsel mentions that they refers to personal rights. However, they stated the violation happens when there is breach of the fundamental rights to be heard, which is a matter of Swiss public policy. Thank you.
Thank you very much, Madam Nkrumah. Mr. Aidi?
Thank you, Mr. President. I will be brief. First of all, discussing the jurisdiction of CAS. If we clearly read Article 82 of the FIFA Code of Ethics, it is clearly stated that decisions taken by the adjudicatory chamber are final, and they are subject to appeal lodged with the Court of Arbitration for Sport in accordance with the relevant provisions. Thus, we will not get back on this argument. However, the appeal is inadmissible, and I'd like to emphasize on this point. In regard to the second element that has been raised by counsel for the appellant for the admissibility of the evidence, the right to be heard of the appellant has not been breached. The fact that he is here and he's been given enough time to develop his arguments and present them to this panel is an illustration of the right to be heard and the right to a fair trial. The exhibit is admitted. That is standard practice in CAS because it has limited investigative powers. Thus, we urge this panel to admit the two pieces of evidence because they are admissible. Thank you for your attention, and this concludes our sub-rebuttal.
Thank you very much. I see Arbitrator Crespo wishes to ask something or say something.
Yes, thank you very much, Mr. President. I have a couple of questions for Mr. Aidi. The first one, I'm a bit surprised when you said that there's a football list of football arbitrators and they couldn't nominate anyone from outside this. I want you to develop a bit that because it's not my experience. FIFA can nominate anyone. It's not a matter. And after the Penstein case, I think that it's much better to nominate somebody who is not linked to football sometimes. So just in a couple of minutes, if you don't mind, can you explain me that, please?
Yes, of course, Mr. Arbitrator. I understand your concern. I will answer your argument. I'll answer your question by raising three arguments. The first one is that CAS is a closed system list, which means that if a party is bound by will present a hearing before CAS, it has the obligation to pick an arbitrator from the said closed list. There's a list of over 300 arbitrators, and then each arbitrator has a level of expertise, either football, gymnastics, etc. That was the submission. Perhaps I was not clear enough, but the number of arbitrators specialized in football is 130. That is why I made this argument. In regard to the second point I'll be raising is that multiple appointments in sports arbitration are a welcome sign of expertise. If I may give you some examples, FIFA has nominated in 3 years a Spanish arbitrator 9 times and an Argentinian one 13 times, and none of these cases gave rise to challenges over the lack of independence of both these arbitrators. And finally, the last point I'll be raising to address your question, Mr. Crespo, is that here, Ms. Umayma, she disclosed said information. She did so, even though she was not bound by it, because the IBA guidelines, specifically footnote 5 under section 313, clearly say that if an arbitrator is appointed multiple times in sports arbitration, they do not even have the obligation to disclose. However, she did so, proving the will of Ms. Umayma to relieve us of any doubts. If this satisfies your question, Mr. Arbitrator, I'll conclude on this point.
Yes, now I understand that when you said you couldn't name anyone else, that was a bit surprised. So, and the second question is about Professor Sarah Umayma. She said, I have acted as sole arbitrator, president, and co-arbitrator in 4 arbitration before proceeding to FIFA when FIFA was a party. But my point is, why couldn't you disclose when she acted as sole arbitrator, when president, and when a co-arbitrator, and when FIFA nominated as a president, not, but as a co-arbitrator? I mean, we should know that. in order to see if there is a possibility of challenging or not. Sole arbitrator is nominated by ICAS, that's fine. President also by them, but co-arbitrator. Although 2, 1, nil, I don't know. So it would be fine to know that. And you are FIFA, so you should have that now. And if you don't mind, you can answer that, please, in the next minutes.
Yes, of course, Mr. Arbitrator. Well, again, I'll be making 2 points. First of all, Ms. Umayma we do not have any indication over the scope of such a disclosure. In fact, she is not bound neither by the IBA guidelines or by the CAS procedure rules to give information. And when the appellant asked for this information, she simply stated that she had yet to provide it. Indeed, she disclosed it 5 days ago, and perhaps in the meantime, she did not get the opportunity to answer. But here, once again, she is bound by a confidentiality obligation. This is clear in Article R43 of the CAS procedure rules, to which I direct the members of the panel. It clearly states that the arbitrator, in this case, Ms. Umayma, has to ask for CAS's permission before she will disclose such evidence, such elements, whether she was appointed by a party or the other, the verdicts of these decisions, and whether she was with other arbitrators. And this operation here will take more time than the simple 5 days she had. That is why we submit that she did not yet provide this information, because she is waiting for the permission of CAS in order to be able to provide the 3 information that you asked for, Mr. Arbitrator.
So the question for Mrs. Nkrumah, why didn't you ask CAS to force Mr. Umayma to make us know exactly when she was nominated as a co-arbitrator by FIFA or not? So did you provide that, or did you ask for that?
Honorable Tribunal, I will ask you to go to the PO1 at page 10, specifically paragraph 31. It clearly states, in the proceedings where Mrs. Umayma acted as a president and sole arbitrator, how did the appointment procedure work? In the proceedings where she acted as co-arbitrator, was she appointed by FIFA? This information is not available. Ms. Atom has asked for this information, but Ms. Umayma has yet to provide it.
Thank you. And I'm sorry to say, so then now I'm going back to Mr. Aidi. Did FIFA do anything to avoid CAS to disclose those nominations? Because I'm a bit surprised. It seems that the other party, the appellant, did its job. So can we know that? Because we are very much, concerned about those small but important issues.
I understand your concern, Mr. Arbitrator. If I may speak on behalf of FIFA here, there were not any actions made in order to slow down the process to get information. The only thing that FIFA did was appoint a competent and independent and impartial arbitrator. And then again, if I may refer to the same paragraph quoted by counsel for the appellant, they did not ask CAS to provide them this information. They simply said that Mr. Atom has asked for this information, but Ms. Umayma has yet to provide it. Thus, in these 5 days between the disclosure and the day of the hearing in which we are today, we simply did not have enough time to ask for the information and to provide it. However, I can assure you, FIFA did not partake any actions to slow down the process. It will actually be in our benefit if every doubt can be raised, even though there isn't any in this case here. Ms. Umayma is independent, competent, and we urge you to recognize that as well. Apologies, Mr. Arbitrator, I think you are muted.
Thanks for the answer, but 5 days more enough for FIFA to understand, to know, because they have a list of who they have named in which arbitration. But anyway, this is just questions from the arbitrator here. I don't know if Horacio, Francisco, you have anything else?
I have a few questions, but I would welcome Dr. González Mullin's views first.
Yes, I have some question for the respondents. I'm sorry, Mr. Aidi. One of them is regarding the jurisdiction of CAS. If you read the page number 3 of some case number 3 and 4, numeral 3 and 4. On 27 May 2020, the adjudicatory chamber issued a decision, and the grounds of the decision were notified to the appellant on 31st July 2020. And the appellant submit his intention on 3 August, 3 days after they knew the grounds. And then on 10 August, the appellant filed the appeal. So the appeal was filed by the appellant in the first 10 days after he knew the grounds. Why didn't, don't you think that it's not relevant that FIFA didn't say anything about this appeal? Because when they filed the appeal, they had time, well, the appellant has time to file the appeal against before the task. Don't you think that the attitude of FIFA is not relevant regarding the jurisdiction of CAS?
Allow me to clarify, Mr. Horacio. First, the dates that you gave us are the dates of the appeal that was submitted to the FIFA Appeal Committee. However, Article 82 states that the appeal should have been lodged before the CAS, the Court of Arbitration for Sports. And to address your question, that is why we are not making the argument here that this appeal, that CAS does not have jurisdiction, or that this appeal is inadmissible. Indeed, we have agreed with counsel for the appellant on this point, for the only reason that FIFA did not raise this argument before the FIFA Appeal Committee, and it should have. But since it did not raise that argument, we deem it against the principle of good faith and the duty to arbitrate in good faith to raise it now. We simply explain the argument, the theoretical aspect of it. However, we are not raising it before this panel to take under account these elements. But to strictly address your question, the dates that you gave, the fact that it was notified on the 31st of July and that the appeal was lodged on the 10th, these dates are not they are not talking about the dates you are mentioning. This is for the appeal committee. The date in which the appeal was presented to CAS is in fact the 20th of April. And here we know that the 20 days were not respected. Between July and April, we have even more. We have a few months actually, even more than 20 days. That is why we explained this argument. However, again, we cannot make it and still arbitrate in good faith. That is why we did not. I hope this explains the answer, Mr. Arbitrator. Otherwise, I will develop further if you'd like.
Okay, and thank you. And the second question is regarding the opinion of Mr. Vax. Mr. Vax said that people who oppose vaccine mandates pose a danger to public health. The appellant is one of them. Then he said that this free rider attitude is incredible, unfortunate, and egoist. And then he said that these are uneducated people who think only about themselves. Those qualifications are the appellant is one of them. So don't you think that these opinions doesn't affect or don't affect the impartiality of Mr. Vax? Knowing that the appellant is one of the one that opposed vaccine mandates.
I completely understand your concern, Mr. Arbitrator. Again, to address your point fully, I will raise 3 arguments. The first one is that the wording used by Mr. Vax in this comment shall be considered as merely unfortunate. And to this, I quote a case that has been rendered under the LCII rules, and in which one of the arbitrators stated that he hates the guts of counsel of the other party. He hates the way they talk about them. And maybe this gives memory to Mr. Presiding Arbitrator. But in that case, they deemed the word to be merely unfortunate, but are not enough to give rise to legitimate doubts over his impartiality. The second argument we'll be making is the Sunyan case. In that case, Mr. Arbitrator, the wording was a lot harsher. It can be considered as hostile, even racist. Even in that case, they do not consider the challenge should be upheld because it did not give rise to legitimate doubts over the impartiality of the arbitrator in that case. And as I have already mentioned, without spending too much time on this point, different studies, recognized studies, clearly state there's a link between people being hesitant toward vaccination and the lack of higher education. Thus, these elements are simply an objective opinion of a president of an NGO that deals with eradicating diseases. People who are unvaccinated, in his opinion, and this is scientifically backed, they do indeed pose a danger to public health. However, this does not in any point, in any case, give doubts over the fact that he will hear the case, hear the merits on the case, and decide strictly on law, on the relevant facts, nothing with the opinion of vaccination. And finally, to conclude, Mr. Arbitrator, let's say that this was not about vaccination, but about flat earth theory. If the appellant was in the flat earth society and the president here was simply working with NASA or any other jurisdiction, then in that case, it would have nothing to do. This is simply a scientific debate in which two people who think freely are opposed. This does not give rise to legitimate doubts over his impartiality. And I hope this answers your question, Mr. Horacio. You are still muted, Mr.
Thank you, Mr. David.
Thank you.
Thank you very much.
Madam Nkrumah, in support of your very eloquent presentation, you asked that this tribunal consider Article 6.1 of the European Convention on Human Rights. Do you recall that? Is that convention applicable to arbitration?
Honorable Tribunal, it is not applicable directly, but as it has been discussed by Rigotti as well, and cases such as Fuzimaoli enunciated, CAS jurisprudence has stated that when we are dealing with issues such as the rights to be heard, the ECHR applies indirectly, Honorable Tribunal. And furthermore, Switzerland is a signatory of the ECHR, and thus it is reasonable to consider it.
And I query how we should consider it, because the European Convention, as does most international humanitarian law, establishes duties upon or incumbent upon states, and they are internationally liable for the disrespect by their organs, such as the judiciary, of that convention. But are my fellow arbitrators, Dr. Crespo and Dr. González, Mullin, and myself, are we judges? Can we act or omit in a way that we can engage the liability of any state?
Honorable Tribunal, we stated that it's a matter of Swiss public procedure order. And as we've already discussed in the Swiss constitution, the right to a fair trial and equal treatment is a matter of procedure. So thus, if this tribunal is dealing with serious breaches of due process rights, then it is expected that this Swiss procedure, public procedural rules are considered.
Thank you, Madam Nkrumah. Mr. Aidi, you made reference twice to the Sunyang case. And unless I misunderstood you, on the first intervention, you mentioned that the questions raised against the arbitrator, who echoed in social media very unfortunate comments like they can go to hell, and other comments I wish to not repeat. Wasn't that award eventually annulled?
Well, first of all, Mr. President, a formal challenge was first made before the ICAS, and then the ICAS did not recognize this challenge. It held that it does not have enough grounds to support the challenge, and then it was eventually challenged before the Swiss Federal Tribunal. However, on the question of challenge, the Swiss Federal Tribunal held that this did not give rise to legitimate doubt, whether it was annulled on other circumstances or on other merits is here outside of the scope of the challenges made against the arbitrator that held the words that you have mentioned again.
Thank you, Mr. Aidi. I think you're correct on the facts on those first challenges, but my general point is that if one relies on Sunyang, which annulled an award, which has to do with statements in social media, such as statements that Mr. Vax made, shouldn't we conclude that your authorities cut against your theory?
Thank you for your question, Mr. Arbitrator. I understand your concern. If the award was annulled on other grounds, then we submit that this has nothing to do with the question of challenge. If the Swiss Federal Tribunal stated on the question of challenges and recognized them to be irrelevant, then maybe this panel should do as well. But to give you other two cases in which the Swiss Federal Tribunal did not give rise to the doubts over the challenges made against arbitrators, the first case is against a challenge that has been made against Professor Ulrich Haas. This was a case, the Valverde case in 2010, and the grounds were even higher than, or should be considered more serious than the case we have at hand. And then the Swiss Federal Tribunal declared them insufficient and did not annul the award based on the challenge. The second case is the Mutu case, in which the same arbitrator, Mr. Dirk Martens, was appointed twice by Chelsea, and both times the arbitrator awarded loss, and even then they did not consider them to lack independence or impartiality.
Very intelligently answered, but I query whether you're not missing the point. The point is that an award was annulled because of social media statements. Mr. Vax made social media statements. Doesn't Sun Yan militate against the theory you're presenting in this case?
Well, to briefly answer your question, Mr. Arbitrator, the wording that has been used in this case here, first of all, does not give grounds to any doubts. However, to answer your question on the Sun Yan case, the fact that these words were considered racist, broadline, disrespectful, did not give rise to a challenge, and even if it was annulled on other grounds, is here relevant for the interest of this panel and shall be considered simply on that regard, not on the case of the Chinese swimmer in general.
So you would distinguish Sun Yan on the content of the comments, not the principle that the cause of annulment was social media derogatory statements, but the fact that the statements made in Sun Yan were clearly very different than the statements we have now?
Well, Mr. President, as you said, the wording here does not resemble the wording used in Sun Yan. Thus, the principle perhaps should be applied, but the circumstances shall be distinguished here. That is why we urge this panel to not recognize in these words a lack of legitimate doubts, because there isn't a lack of impartiality, because there isn't one.
Thank you, Mr. Aidi. Ms. Nkrumah, regarding this last answer, if we take your view, wouldn't we be chilling natural comments that any citizen normally has and could have in a time of crisis like COVID, and we would be asking too much of arbitrators, sending a message that as arbitrator, you're well advised not to echo any comments, not to have an opinion, simply because somebody can use it against you, take it out of context. And in addition to this, I query whether if we take that route, we would be putting out of the equation precisely the type of persons we want as arbitrators. Arbitrators, citizens who are privy to the dilemmas we're living in the world, usually are very smart citizens, people who think, and wouldn't that be precisely the type of person you want as an arbitrator?
Honorable Tribunal, first of all, I would like to redirect you to Exhibit 7 at page 27. And there is the arbitrator with me. We can clearly state that a state independent arbitrator. So this is the only comment of Mr. Vax as of now, and he's not active on LinkedIn, but he has such resentment towards unvaccinated people that he had to go and let it public that he deemed them to be uneducated people. Honorable Tribunal, I would like to reply to opposing counsel comment on scientific grounds. Mr. Vax is stating, in my opinion, there is no backing with statistics. He's not a scientist, Honorable Tribunal. Furthermore, for the Sun Yan case, we would like to highlight that the Federal Tribunal stated that an arbitrator can actually publish their convictions online. However, due to the choice of words and the circumstances at hand, there was a justifiable doubt as to the impartiality. Honorable Tribunal, opposing counsel is stating that there was strong word used in the Stylian case. How high does the threshold have to be in order for us to actually see that there's a clear appearance of bias coming from Mr. Bax? The Stylian case clearly states that we have to look at the circumstances at hand and the choice of words. And as it has already been initiated by you, Honorable Tribunal, uneducated people who only think about themselves and who are egoistic. We are dealing with a serious crime such as bribery, which often has adjectives such as egoistic, self-seeking, and corrupt. How can we expect an arbitrator with such strong convictions to provide a strong judgment free from bias? Thank you.
Thank you, Ms. Nkrumah. One final question that I would ask that you both, Madam Nkrumah and Mr. Aidi, answer very briefly because it's a little bit late and we still have to hear substance. It has to do with unlawful evidence. I query whether we are not, by doing this balance of analysis balancing act between different considerations, whether we're not relativizing or making relative an absolute concept, which is if the evidence is unlawfully obtained or somehow breaches an important rule of the applicable law, it should not be used during cases. Madam Nkrumah, I would start with you briefly, 30 seconds, and then Mr. Aidi.
Honorable Tribunal, we stated that unlawful evidence can be admitted as long as the rights to be heard are respected. Thus, public interest, we acknowledge that might be important, but we are requesting that the right to have a fair trial and due process to ensure the future perseverance of an award is preserved, Honorable Tribunal. Thank you.
Mr. Aidi?
Yes, thank you, Mr. President. First of all, FIFA has limited investigative powers. The fact that it does not have the police powers of a national jurisdiction in order to investigate and to start to gather evidence. Here, this screenshot was given to it by an anonymous source. FIFA does not breach any articles of law itself. It simply obtained this source, and the anonymous witness statement was heard before the Hardadian judges. And here, this is evidence. This has been accepted in the Fuzi Malawi case, quoted by counsel for the appellant, the Adamu case, and in the Metalis case. Thus, we urge this panel that even legally obtained evidence should be admissible when the case at hand deals with corruption. Thank you, Mr. President, members of the panel.
Thank you, Mr. Aidi. Dr. Crespo, Dr. González, Mullin, any further questions?
We could go more and more for hours, but we have limited time, so I'm fine.
Okay, I agree with my distinguished co-arbitrator. Should we start part two?
Yes, thank you, Mr. President.
Thank you, Mr. Presiding Arbitrator, members of the panel, esteemed colleagues. As previously introduced by my co-counsel, my name is Shahrazade Sabil, and I'll be representing Respondent, FIFA, in this case against Mr. Atom, the appellant, regarding the merits. Contrary to what counsel for appellant wants you to believe, Mr. Atom is not the object of FIFA's persecution. His actions have seriously damaged the image of football, and he must be sanctioned for that. On the merits, it is respondent's submission that first, the appellant did breach Article 27 of the FIFA Code of Ethics and thus committed bribery, and two, that the sanction imposed by virtue of the FIFA appeal decision should be maintained since it is proportionate. Starting with the first submission. To begin with, the applicable standard of proof here should be applied according to Article 48 of the FIFA Code of Ethics is the standard of comfortable satisfaction. And on that standard, in the Olga Potilistina case from 2018, CAS has stated that the test of comfortable satisfaction must consider several circumstances, such as the importance of fighting corruption in sports and the nature and restricted powers of investigations of sports organizations, bodies just like FIFA, as compared to national authorities. For this hearing, we urge this panel to bear in mind when assessing the evidence that corruption is by nature concealed as the parties involved will seek to use evasive means to ensure that they leave no trail of their wrongdoing. We submit here that the pieces of evidence that the FIFA investigatory body have managed to obtain are sufficient to prove that Mr. Aitam breached Article 27, considering the seriousness and the nature of corruption itself. Article 27 puts out 4 conditions that must be cumulatively fulfilled in order for an offense of bribery to occur. First, the person acting must be bound by the FIFA Code of Ethics. Mr. Aitam is the president of a football federation, therefore he is bound by this code. Moving on to the second and third conditions that must be cumulatively fulfilled is that the person involved must have accepted, given, offered, promised, received, requested, or solicited a personal or undue pecuniary or any other advantage. In the present case, Mr. Aitam was invited by Mr. Kaiser to go to Fancy Capital, as you can see in Exhibit 1, the email. And if the panel is following me to this exhibit, you'll see that Mr. Kaiser clearly said that he will be paying for the plane tickets and the accommodation. And actually, Mr. Kaiser outdid himself. Not only he paid for business class plane tickets that you can find in Exhibit 2, and for the hotel rooms for a modest amount of 19,500 Swiss francs, as he had promised, but he paid for everything. He invited them for dinner at Michelin star restaurants, to luxurious parties. He paid for massages and gave them 2 shiny watches, as you can see in Exhibit 4 in paragraph 12 and paragraph 15. Anything Mr. Aitam wanted, Mr. Kaiser paid for it. Everything would be for free. And Mr. Aitam accepted these undue advantages. He accepted to be financially maintained throughout his stay by Mr. Kaiser. Business was definitely not in the mind of Mr. Aitam during this trip, where he spent most of his time drinking, partying, and having fun with this unethical man that is Mr. Kaiser. On top of that, the appellant accepted the promise of Mr. Kaiser to organize a friendly match between their 2 federations without requiring any payment. And this is relevant in Exhibit 4, paragraph 19. And may I remind the panel that this exhibit should be held admissible and is relevant documentary evidence to this case. Indeed, this football match would have been very profitable to the appellant personally. Indeed, the panel should keep in mind that Mr. Aitam is married to a major shareholder of the only broadcaster of Thailand, as you can see in the fact pattern in the very first paragraph. It is then highly plausible that the couple has a shared bank account, like many married couples do. Therefore, Mr. Aitam's wife's profits would be his too. Therefore, we submit here that the luxurious trip, the parties, the watches, and the promise of organizing this profitable football match fall into the scope of Article 27. Finally, after the criminal proceedings against Mr. Kaiser, 2 years after receiving these advantages, Mr. Aitam transferred 20,000 Swiss francs to Mr. Kaiser personally, not to the federation, to Mr. Kaiser personally, as you can see in Exhibit 3, the bank statement. And he made this transfer on the 8th of September 2018, 2 days after Mr. Kaiser was convicted of bribery. And counsel for appellant would like you to believe that the timing is a pure coincidence. The fact that Mr. Aitam restituted this sum of money is not enough to prove his good faith and to put aside the rest of the fact that speaks for themselves. On the contrary, it cannot be a mitigating factor. This is a sign of guiltiness. He was feeling guilty. It shows that at that point, Mr. Aitam realized he was guilty, or that he might be convicted of bribery by a criminal court, just like Mr. Kaiser, and just like the 5 other officials that were invited in the same terms of the appellant, as it was stated in PO 1, page 6, paragraph 9. What is even more alarming here is that instead of informing FIFA about his doubts, he preferred to say nothing and reimburse Mr. Kaiser. Finally, the 4th condition that must be met here, is that these advantages were given in order to obtain or retain business or any improper advantage. Here, Mr. Kaiser, through his actions and gifts, incited Mr. Atom to vote for him, and that is clear by having a look at Exhibit 5. And if the panel is following me, you'll see that Mr. Atom is clearly saying, after all they did for us, the least we can do is vote for them. And here we cannot say that the appellant freely voted for Big Land because it was a better fit. Any country can become a better fit with the right amount of money and the right amount of advantages. And I would like to remind the panel what it involves to host a World Cup. It can be a boost for the economy of a country. It is any country's dream to host a football World Cup, and Mr. Atom participated in making Mr. Kaiser's dream reality by participating in a sophisticated corruption scheme. Moving on to the respondent's last submission, the sanction imposed by virtue of the FIFA appeal decision should be maintained. As a reminder, the FIFA appeal committee sanctioned the appellant to a 15 years ban and a 50,000 Swiss francs fine. These sanctions should be considered as proportionate since Mr. Atom breached Article 27 of the FIFA Code of Ethics. First, if you have a look in Article 27, especially its third paragraph of the FIFA Code of Ethics, nothing prohibits the introduction of such a sanction. And we already anticipate appellant's argument on the fact that the reimbursement should be a mitigation factor. However, we have already taken this reimbursement into account by not applying the minimum fine of 100,000 Swiss francs. The second point respondent would like to make is that according to the Quasi case that was rendered in 2020, it is clear that the interest of FIFA in applying a zero tolerance approach towards all kinds of corruption and the will of protecting the football community should be taken into account here. Moreover, some aggravating factors should be taken into account. The fact that Mr. Kaiser is an experienced football official and the importance of the FIFA World Cup. To simply conclude on that point, I would like to say that it is FIFA's rights and obligation to send an important message for all members of the sporting community acting in whatever capacity. If one is involved in bribery, then one may expect to exile from the sport. It does not matter if Mr. Atom knew or not that he was being bribed. It does not matter if Mr. Atom passively or actively participated in a corruption scheme. Corruption is corruption. A finding of bribery should attract a sanction. In view of all the elements that I have previously stated, respondents respectfully request this panel to consider that the appellant did breach Article 27 of the FIFA Code of Ethics, and that the sanction imposed by the FIFA Appeal Committee should be maintained since it is proportionate. Members of the panel, this concludes my submission, and I thank you for your time and attention.
Thank you very much, Ms. Sabil. Again, just in time. I appreciate your effort. And I turn the floor to Mr. Fach.
Thank you.
Did I pronounce it correctly?
No, you did not. It's Fach, but it doesn't matter.
Fach, thank you. No, please, thank you.
Thank you, Mr. Presiding Arbitrator. Honorable members of the tribunal, I would now like to address the merits on behalf of Mr. Atom. I would like to mirror the structure brought up by the opposing counsel, and therefore I shall equally make two submissions. First, that there was no breach of Article 27, Section 1 of the FIFA Code of Ethics, and second, that even if there was a breach, the sanction imposed upon Mr. Atom of a ban of 5 years and a fine of 50,000 Swiss francs is grossly disproportionate and must be reduced. Under Article 27, Section 1, 3 requirements must be met cumulatively and with the standard of comfortable satisfaction. First, that a person is bound by the FIFA Code of Ethics. Second, that it received any pecuniary or other undue advantages. And lastly, that it received those advantages in turn for granting a business opportunity to someone on behalf of FIFA or outside of FIFA. Now, the opposing counsel equally raised the standard of comfortable satisfaction. And then she referred to the decision of Olga Paritsina versus IOC from 2017 with the case number 5432. However, in that very case, it is stated that not only the circumstances shall be considered, but also that the more serious the allegation is, the more cogent the supporting evidence shall be. And this has been confirmed in the decision of Moon Young-jun versus FIFA, the case award from 2017, with the case number 5086, in which a Korean football official was being disciplined. And the court held that the more serious the allegation is, the higher the threshold should be for the tribunal to be comfortably satisfied. In light of this, and in light of the present circumstances, I submit that while Mr. Atom is bound by the FIFA Code of Ethics, he did not receive any advantages, and there was no quid pro quo. Regarding the advantages, I would like to address those in turn, and I would like to start with the trip Mr. Atom and Mr. Lenders undertook to Bigland. Because the opposing party wants you to believe that this was a luxurious vacation that they undertook. However, the opposite holds true. If we look at the agenda of Mr. Atom and Mr. Lenders and their trip to Bigland, we see that they visited training facilities, football stadiums, and touristic hotspots. And they did so because they wanted to make up their mind about the upcoming World Cup election. Therefore, it was a fact-finding trip and not a luxurious vacation. The opposing counsel already addressed the reimbursement of 20,000 Swiss francs, and she stated that it will be appellant's argument that the timing is pure coincidence. However, members of the tribunal, this is not our submission. The timing is not by coincidence, because this is the day that Mr. Kaiser got convicted in Heartland was the day that Mr. Atom realized what he had gotten himself into. And that's why he immediately reimbursed Mr. Kaiser for the trip that was paid by Mr. Kaiser up to that point. Therefore, the fact-finding trip does not constitute an advantage under Article 27. Further, the opposing counsel referred to parties, shiny watches, and drinking. However, members of the tribunal, all these alleged advantages derive directly from the anonymous witness statement. And irrespective of the admissibility of the witness statement, I submit that it should not be given too much weight. And in order to substantiate this argument, I would like to walk you through the witness statement. It starts on page 9 of the record, Exhibit 4, and within the Exhibit 4, it is the first page. Now, if we look at the first page, it becomes evident that most of the information was redacted. Now let's go to the next page. Again, most of the information was redacted. So the witness statement really starts on the third page. Now I'd like to read from paragraph 13. I arrived at the restaurant at 8:30, half an hour ahead of schedule, to catch up with some emails over an aperitif. Now let's go to the last page of the witness statement, paragraph 19. My colleagues arrived soon after, so I stopped paying attention to the conversation. And then also, excuse me, I would like to refer you back briefly to the last paragraph 13, the last line. I could not identify these individuals as I was just facing their backs. So to recap, this is a witness that is drinking alcohol, checking his emails on his phone, talking to his company, and who could not even identify the persons he is talking about. Therefore, this does not meet the standard of comfortable satisfaction that Mr. Atom actually received any advantages. Lastly, I would like to address the TV revenue that Mr. Atom allegedly accepted, because the opposing counsel stated that appellant accepted this TV revenue. However, members of the tribunal, this is simply not true. I would like to refer you again to paragraph 19 of the witness statement, and I would like to read to you what Mr. Atom said in the fourth line. We would be happy to talk to the broadcaster so that the revenues could be split at a 50-50 rate. That is the proposal by Mr. Atom. Now, Mr. Kaiser responded in the last line, you get to keep all the revenues. And then in the first line of paragraph 20, it states, as the night went on, it became increasingly difficult to follow the conversation. So in this witness statement, there's no indication whatsoever that the appellant ever accepted the proposed 100% TV revenue. And I would like to reiterate that the burden of proof is on the opposing party to show that there was such an acceptance in a breach of Article 27, Section 1. Thus, Mr. Atom did not receive any advantages from Mr. Kaiser, and even if he did do so, there was no link between the vote that was cast in favor of Bigland and the alleged received advantages. In other words, there was no quid pro quo. The opposing counsel here referred to Exhibit 5, the telegram conversation. However, we still don't know where the telegram conversation is from, who obtained it, and when it was obtained. Therefore, this does not sufficiently prove that there is a link between the vote being cast in favor of Bigland and any alleged advantages. And with that, members of the tribunal, I would like to conclude my first submission and state that there was no breach of Article 27, Section 1 of the FIFA Code of Ethics. I would now like to move to my second submission, which is the proportionality of the sanctions. And I submit that a sanction of a ban of 15 years and a fine of 50,000 Swiss francs is grossly disproportionate and must be reduced. And this is based on two main arguments. First, because the circumstances of the case indicated, and second, because this disproportionality also becomes evident when looking at cast jurisprudence. However, before going there, I would like to address the opposing party's argument regarding Article 27, Section 3, which is allegedly calling for a higher sanction. It is our position that this article is not applicable in the present case. And this is because it is consistent cast jurisprudence that generally the principle of tempus regit actum shall apply, which means that an individual's misconduct shall always be judged by the FIFA Code of Ethics that is in place at the time the alleged misconduct took place. Now, we understand that Article 3 of the FIFA Code of Ethics 2018 provides for a retroactive application. However, as this directly contradicts the principle of tempus regit actum, this issue has been resolved in the decision of Moon Young-jung versus FIFA. And the panel held that such a retroactive application is permissible to the extent that it does not entail any harsher sanctions than those that were in place at the time the conduct took place. If we look at the fact that the conduct took place in 2016, where the FIFA Code of Ethics 2012 was in place, and at the fact that the FIFA Code of Ethics 2012 does not provide for an equivalent to Article 27, Section 3 under the FIFA Code of Ethics 2018, we must come to the conclusion that this provision is not applicable. Now, I would like to turn to the circumstances of the case and argue why the sanction is grossly disproportionate. I would like to refer to the decision of Moon Young-jung and to the case of Cossío versus FIFA, to which the opposing counsel equally referred. In both cases, it has been held that an individual's commendable service to the football community, as well as a lack of priors, must be considered as mitigating circumstances. And both of these circumstances are in place in the case at hand. First, Mr. Atom has been working for the Football Federation of Thailand since 2009, and thus he was greatly contributing to the well-being of the football community of Thailand. And secondly, there's no indication whatsoever regarding any impropriety or any misconduct in his past. Therefore, these mitigating factors shall be considered. Equally, the opposing counsel stated that it doesn't matter if he participated actively or not, or if he knew that he was getting bribed. However, members of the tribunal, the opposite holds true. If we look at the case of Cossío versus FIFA, that the opposing party also relied on, it becomes evident that in this case, the sanction amounted to a 15-year ban because Mr. Nyantici himself set up a bribing scheme and was playing an active role in conducting bribery, opposed to Mr. Atom, who allegedly took only a passive part in bribery. Therefore, the circumstances of the case call for a lower sanction. Now I'd like to briefly address why also the CAS case law calls for such a lower sanction. First, if we look at the case of Amos Adamu versus FIFA from 2011, with the case number 2426. This case involved Mr. Adamu, who was approached by investigative journalists and met with them repeatedly and showed clear intent to commit bribery, and both was recorded on audio and video. Nonetheless, the sanction only amounted to a ban of 3 years and a fine of 10,000 Swiss francs. Equally, in the case of Ramon Maradiaga versus FIFA, a case that involved both match fixing and bribery, the ban only amounted to a ban of 2 years and a fine of 20,000 Swiss francs. Now, therefore, the sanction is grossly disproportionate, and I would like to conclude with one last sentence. The opposing counsel stated that FIFA must send a message to the people regarding the non-tolerance regarding bribery. However, Mr. Atom cannot be a pawn that is being sacrificed to send this message. Thank you.
Thank you, Mr. Fach. So we turn back to Madam Sabil for the 1 minute rebuttal.
Thank you, Mr. Presiding Arbitrator. First, I would like to come back on the words used by the opposite counsel. Mr. Atom realized at some point that he had been corrupted, that he got into a scheme of corruption. And instead of accomplishing his duty to report according to Article 17, paragraph 1 of the FIFA Code of Ethics, he did this reimbursement. And he had 6 months from the reimbursement to the starting of the proceedings before FIFA to say something, and he remained silent. Another point that I would like to raise is on the content of Exhibit 4. This statement does show relevant facts. The witness statement was right about the date, since it can be confirmed by the plaintiffs. He was right about the incitement of Mr. Kaiser to Mr. Atom to vote for him. He was right by quoting the exact words used by Mr. Kaiser. Therefore, it urges panel to take into consideration the content of the statement. This concludes my rebuttal. Thank you.
Thank you, Madam Sabil. Mr. Fach?
Thank you, Mr. Presiding Arbitrator. Regarding the failure of Mr. or the alleged failure of Mr. Atom to report the bribery by Mr. Kaiser, if this were to constitute an offense under Article 17, then the FIFA Ethics Committee can initiate proceedings regarding Article 17. But today, we are talking about the breach of Article 27. Secondly, the opposing counsel argued that Exhibit 4 proves sufficient facts. However, members of the tribunal, this piece of evidence was in front of a criminal judge. And even though this criminal judge reviewed the evidence, there is no indication whatsoever that he investigated or convicted Mr. Atom because of a breach of Article 27 or comparable crimes. Thank you.
Thank you both. I yield the floor to my fellow co-arbitrators for the questions.
Thank you, Francisco. I have a couple of questions, one for each of the parties. The first one is for Mrs. Sabil. You just said, and your opponent also put it on the table, the image of football is the one you have to protect. So it makes me uncomfortable to see that this is not a case against Mr. Atom. You said that clearly. I just put it in written. Not a case of Mr. Atom himself, but a case of image of football. Do you think that an ethics case, which is a disciplinary case, shouldn't be against the one who has misbehaved and not for the good of football or the good of the game? I want you to explain me a bit more about that, because I'm really concerned about how FIFA is dealing these cases.
I understand your concern, Mr. Arbitrator. If I understood correctly your question, you're asking me how would these the acts of Mr. Atom impact the image of football? Is that right?
I'm just following your initial statement. You said this is not the case against Mr. Atom himself, the case for the image of football. And then, of course, you said more and more about the bribery and so on. But my point is, don't you think that is as a disciplinary case, because ethics is a disciplinary case, and you have to sanction an individual is misbehaving? Don't you think that is going much further than what you have to do? And what FIFA is doing is something that is not in its possession. They should just go for the facts against the one who has misbehaved, and then the image of football in those general issues are not to be taken into consideration. I mean, this is the concern I have. If I'm in the position, I would never be there, but in the position of Mr. Atom, would have loved to be sanctioned because of the image of football or just because of my behavior?
Okay, I understand clearly now your question. Thank you, Mr. Arbitrator, for rephrasing. Well, by sanctioning Mr. Atom, the FIFA is making sure that no one would think that just because you're qualified, just because you were, and I quote the words of the opposite counsel, an honest man, you could have, you could not be sanctioned of corruption. And I would like to insist on words that were used by the CAS in the Fouzi Maloui case, where CAS has clearly said that the FIFA World Cup has no place for dishonesty, has no place for bribery, and the actions of Mr. Atom and also the actions of Mr. Kaiser and the 5 other officials did impact the image of football and the image of the World Cup. And by sanctioning this person and by sanctioning Mr. Kaiser, because I just want to remind the panel that we're actually investigating Mr. Kaiser, Mr. Atom, by sanctioning Mr. Atom, it will protect football. It will make us believe that Mr. Atom will not have the chance to retaliate, to again act unethically.
I understand, but it was not my question. Is how do you put on a higher level the image of football than the behavior of one individual. That's what you said in your very, very starting point. So I want you to just elaborate about this. Are we going to be in those disciplinary cases in a case in which you have the image of football in one and then the misbehaving of the other? I want you to elaborate about this because it concerns me as an arbitrator. So forget about what you said in my, you answered me correctly, but not on the question, the proper question I made and the proper answer I need to receive from you.
Thank you, Mr. Arbitrator. Well, Mr. Atoms did impact football. He did impact the World Cup and the bids of the 2026 World Cup. And he did impact and weakened the football community because, again, corruption is a growing concern in football. And if we look at the case of Mr. Atom, he is a person who is participating in the growth of corruption in football. So we believe that by sanctioning him, this will protect the football community.
Okay, thank you. And for Mr. Fach, I would like you to go to Exhibit 5 and explain me what do you understand? What is your explanation about the wording? Crazy night, yes, we cannot draw back, yes, we have to vote for them. Just an explanation. What do you think? But I mean, admissible or not? This is another issue.
Mr. Arbitrator, I would like to, I understand that there is some ambiguous wording in this Telegram message, and I don't want to dispute that. However, I would like to read on one message specifically to you, which is the third message. They really know how to do things over there, don't they? Now, if we look at this, this just goes to show that they made up their mind about Bigland because they understand that Bigland is a suitable country to host the World Cup. Therefore, this piece of evidence could go both ways. It could indicate that there is a possible link to an alleged advantage. However, it could also indicate that it just shows that Bigland is the suitable country to host the World Cup 2026. And therefore, we submit that this does not sufficiently prove a quid pro quo between alleged advantages and the vote being cast in favor of Bigland.
Okay, so you think that is not a link and it's not a quid pro quo between one and the other, because they said that we cannot draw back and we can't, if the least we can do is vote for them. You don't see there a quid pro quo.
Mr. Arbitrator, I don't want to lie to you right now and say that this is a perfectly fine wording, which is perfect for our client, because it is not. However, what I would like to reiterate is that we still don't know whose phone this is, when it was obtained, who sent the messages, who obtained it, and therefore it just does not meet the standard of a comfortable satisfaction. If this was a recorded conversation between Mr. Atom and Mr. Lenders, such as, for example, in the case of Amos Adamu versus FIFA, then maybe this would meet this threshold of comfortable satisfaction. But in this format, it does not meet such threshold.
Okay, I'm fine, Francisco Horacio.
Dr. González Mullin.
Oh, thank you, Mr. President. It's okay for me.
Thank you. Mr. Fach, you mentioned that the standard of evidence for, or should be correlative to the seriousness of the allegation. Do you recall that in your presentation? Would you agree that seldom does unlawful activity such as bribery leave direct evidence?
Mr. Arbitrator, I would agree that sometimes when people are actually committing a crime, they would try to keep it secret. However, I would submit that this must not deviate from the standard of comfortable satisfaction, because if this were to be the case, then the right to be heard, and especially, then the due process rights in general were to be violated, because it would just lower the threshold for crimes in general. And I would like to point out one thing in this regard. If a person that is committing a crime is always trying to be secretive about it, then why did Mr. Kaiser and Mr. Atom allegedly meet in a public restaurant? because they did not commit a crime.
Madam Sabil, what would be your response to Dr. Fach's comment?
Thank you, Mr. Arbitrator. Well, we found the words of the opposite counsel quite shocking. This would mean that if I just murder someone in public, it would mean that I'm not a criminal, that I did not commit the act of murder. So the fact that Mr. Kaiser and Mr. Atom agreed on the fact that Mr. Atom would vote for Big Land in a public restaurant is completely, should completely be disregarded in this case. The facts are here. There's an incitement, there were advantages, and as we can see in Exhibit 5, these Mr. Kaiser incitements did occur, since Mr. Atom clearly said, after all they did for us, the least we can do is vote for them. And they were not talking about visiting the stadiums. They were not talking about visiting the sports facilities or the touristic points. They were obviously talking about the luxurious trip that he had with Mr. Lenders, on the parties, the massages, the free restaurants, etc., the bottles of champagne. They are not talking about an objective point of view on Big Land. They're talking about how they were treated by Mr. Kaiser in order for them to vote for Big Land. Thank you.
Thank you. I'm done with my questions. If my fellow co-arbitrators have no more questions, I think we should deliberate.
No more questions.
Thank you, Arbitrator Crespo. I assume that Dr. González Mullin reaction is the same. And if that is true, I ask the sports arbitration moot how we should proceed. Thank you.